We walk around every single day wrapped in this invisible shield. It's completely weightless. You can't see it, you can't touch it, but it basically dictates almost every interaction you could possibly have with the government.
Yeah, but the thing about this shield is that it's not a solid piece of metal, right? It's more like a really complex shifting force field.
Right, exactly. And depending on where you're standing or who you're with or even what you're doing, that force field just like blinks out of existence.
It really is the absolute definition of a moving target. Yeah. And when that force field drops, the consequences are incredibly profound. I mean, we are talking about the difference between walking free and, well, losing your liberty.
So today we are doing a deep dive to test the limits of that exact shield. We're exploring the Fourth Amendment, pulling specifically from an amazing source, the foundations of Fourth Amendment search and seizure law.
It's a great foundational text. And our mission today is to strip away all that impenetrable, dense legal jargon and look at the actual mechanical core of criminal procedure.
Yeah, because we really want to look at those fault lines where your gut legal intuition totally clashes with the reality of constitutional law, which, by the way, is especially crucial if you are analyzing fact patterns for the multi-state bar examination, the MBE, or honestly, just trying to navigate your own civil rights out in the world.
Absolutely. The MBE loves to test those exact counterintuitive moments.
So let's start with the text itself, because everything we are looking at today stems from one single, incredibly dense sentence that was written, what, over 2 centuries ago?
Yeah, and to really understand that sentence, you have to look at the specific anger that birthed it. The framers of the Constitution were largely reacting to the British use of writs of assistance.
Writs of assistance. Sounds formal, but they were pretty awful, right?
They were essentially general, open-ended warrants. They allowed the king's customs officials to just tear apart any colonial home at literally any time, searching for smuggled goods. And they needed zero specific evidence to do it.
So just pure arbitrary power. Like, I don't like you, I'm tossing your house.
Exactly. So when they drafted the Fourth Amendment, they built it to do two distinct things to prevent that exact scenario from ever happening again. First, it explicitly protects four categories: people, houses, papers, and effects.
Right.
And it protects them against searches and seizures that are unreasonable. That's the first part. The second part locks down the actual rules for warrants.
So if the government wants to use a warrant, they need three specific elements, right? Probable cause, an oath or affirmation supporting it, and a really particular description of the exact place to be searched and the specific persons or things to be seized.
You nailed it. And let's unpack those four categories for a second. People, houses, papers, and effects. I mean, people and houses are obvious. Papers cover your documents.
And effects covers basically your personal property, right? Like your backpack, your car, your smartphone.
Exactly. But the absolute linchpin in that entire first clause is the word unreasonable. Because the Constitution does not guarantee that the government will never search you. It just guarantees they won't do it unreasonably.
That's such a huge distinction. That single word, unreasonable, is basically the battlefield for thousands of Supreme Court cases, isn't it?
It really is. The amendment is this constant attempt to balance the legitimate needs of law enforcement to, solve crimes against the individual's right to privacy.
And then the second part, the warrant requirement, that directly targets the trauma of those British writs. A judge can't just hand a police officer a piece of paper that says, search John's entire life.
Right. No fishing expeditions. It has to be surgical. It has to say, search John's detached garage for stolen flat-screen televisions. Specificity is the antidote to arbitrary power.
Okay, so that establishes the shield and the basic rules of the game. But there is a massive threshold issue before we even get to evaluate whether a police officer acted reasonably or if a warrant was specific enough. We have to figure out who actually holds the right to complain when the shield is breached.
Yes, the who. Because constitutional law doesn't just let any random bystander cry foul.
Right. This is the concept of standing. And I know this is the first major hurdle in literally any Fourth Amendment analysis.
It is. Standing, in a legal context, is the right to bring a claim before a court. And Fourth Amendment rights are deeply, inherently personal. You absolutely cannot vicariously assert someone else's rights.
Okay, so to challenge a search or a seizure, I have to prove that my own personal rights were violated.
Exactly. You must have either been personally seized, or you must have what the courts define as a reasonable expectation of privacy in the specific place that was searched or the specific item that was seized.
Okay, let's make this real. Think about a bouncer at a nightclub. You and your friend are hanging out, following the rules, and suddenly the bouncer comes over, completely out of line, and violently throws your friend out onto the street for absolutely no reason.
Okay, classic scenario.
You might be furious. You might think the bouncer violated every rule of the club, but I can't sue the club for kicking me out because my physical person wasn't touched.
Right, your friend has the grievance. You simply observed it.
Exactly. So bringing that nightclub analogy into the courtroom, this strict requirement of personal standing creates some incredibly harsh outcomes, especially in conspiracy
Oh,
cases.
absolutely. Our source text highlights this classic, heavily tested scenario of Al and Bob, two partners in crime. This is a massive MBE trap, by the way.
Yes, let's hear it. Break down Alan Bob.
Okay, so let's say they burglarize a store together and steal a shipment of laptops. They stash the laptops in Al's apartment. Later on, the police illegally kick down the door of Al's apartment. No warrant, no probable cause, just a blatant constitutional violation.
Okay, terrible police work.
Right. They find the laptops, and both Al and Bob are arrested and put on trial. Now, the prosecution introduces the laptops as evidence to convict Bob.
Okay, so Bob's defense attorney obviously files a motion to suppress the laptops, pointing out that the police clearly broke the law to get them. I mean, since Bob is on trial too, and the evidence is being used against him, shouldn't he be allowed to point out the police broke the rules?
You would think so. But based on the rule of personal standing, Bob is entirely out of luck.
Wait, entirely?
Yes. Because he didn't live in Al's apartment, he wasn't an overnight guest there, so he had absolutely no reasonable expectation of privacy in that space.
Oh, wow. That is the exact fault line where your gut, legal intuition, and real-world defense strategies just completely collapse.
It is. In United States v. Padilla, the Supreme Court really cemented this. The fact that evidence incriminates a defendant, or that it was seized from a co-conspirator, is simply not enough to grant standing.
The court essentially separates the shared crime from the individual constitutional right.
Exactly. The police pierced Al's invisible shield, not Bob's. So Al can get the evidence suppressed at his trial, but Bob just has to sit there and watch the illegally obtained evidence send him straight to prison.
Let me stop and explicitly recap this for anyone listening who is looking to master this area for the MBE. Standing is a rigid, individualized test. Co-conspirators do not share Fourth Amendment rights just because they share a criminal enterprise. You have to isolate the specific person raising the objection and ask strictly about their personal expectation of privacy.
That is a perfect summary. It acts as an incredibly effective gatekeeping mechanism for the courts. If you lack standing, the judge will not even entertain your argument about police misconduct. The inquiry just stops before it even begins.
Okay, so the right is intensely personal, but who is that personal right actually defending against? Once we know who can complain, we need to establish exactly who they are complaining about.
Right, the from whom. Because the Fourth Amendment is a specific constraint on governmental power. It strictly limits the state. It offers zero protection against private actors.
The state action doctrine. The Constitution regulates the government, not your neighbors. Let's test the absolute edge of that doctrine with a hypothetical. I live next to a phenomenally nosy neighbor who just watches my house all day.
We all have one of those.
Right. So one night, they decide to kick the lock on my back door, break into my bedroom, steal a locked diary where I've written down details of a crime, and march that diary straight down to the local police precinct.
Okay.
The police read it, find the confession, and arrest me. Now, my house was broken into, my private papers were seized, which triggers the exact text of the amendment. But because it was my neighbor, has my Fourth Amendment right actually been violated?
The Constitution does not apply here at all.
Not at all.
Nope. Your neighbor committed burglary, breaking and entering, and theft. The state can prosecute them for those crimes, and you can sue them into oblivion in civil court. But the police officers sitting at the precinct, they did nothing unconstitutional by accepting evidence handed to them on a silver platter. They didn't conduct the search.
Man, that creates a massive loophole, though, doesn't it? If the evidence comes in regardless of how the private citizen got it, doesn't that basically incentivize the police to just crowdsource their illegal searches?
It totally would, if not for the agency exception. A private person's actions fall under the Fourth Amendment if they're acting as an instrument or agent of the government.
Ah, okay. So how did the courts figure that out?
They look heavily at direction and control. If a detective suspects you of a crime, goes to your nosy neighbor and says, hey, we can't get a warrant for that diary, but if someone happened to sneak in and grab it, we'd make sure their own outstanding parking tickets disappeared. That completely changes the equation.
Because the police orchestrated it. The neighbor is no longer a private citizen acting on their own bizarre motives. They are basically a deputized arm of the state.
Yes. The moment the state directs the action, the invisible shield activates. The Fourth Amendment applies, and the evidence would absolutely be thrown out.
Okay, so we've got the state actor requirement. But while we are analyzing what the government can and cannot do, we have to look at the jurisdictional layers of this shield. The source text brings up a really vital case, Michigan v. Long, which deals with state versus federal power.
Yeah, this is a really important nuance because we naturally default to the federal constitution as the ultimate law of the land. But state constitutions play a fascinating independent role in privacy rights.
The architectural metaphor I always hear here is floors and ceilings.
Exactly. The federal constitution, specifically as interpreted by the U.S. Supreme Court, establishes the absolute baseline, the floor for your rights. No state in the union can dip below that floor.
So a state legislature cannot pass a law declaring that police no longer need probable cause to get a warrant?
Right, that would be unconstitutional.
Yeah.
But they can build up. A state Supreme Court can interpret its own state constitution to provide a higher ceiling of protection, granting broader rights than the federal government requires.
Can you give an example of that?
Sure. Let's look at garbage. Under federal Supreme Court precedent, police generally do not need a warrant to search the garbage you leave out on the curb. The federal court reasoned that, well, you abandoned it, so you have no expectation of privacy.
It makes sense under federal law.
But the state Supreme Courts of New Jersey or Oregon looked at their own state constitutions and concluded that their citizens do have a protected privacy interest in their trash. So in those states, the police actually must get a warrant for your garbage.
That is fascinating. The thickness of the invisible shield physically changes when you drive across state lines.
It really does.
Let me do a quick recap of the two-part checklist for a violation here, because this is prime MBE territory. First, you have to ask, is there a reasonable expectation of privacy, meaning do you have standing? And second, was it the government or its agent doing the searching without a valid warrant? Because if a private citizen acts totally alone, the Fourth Amendment just doesn't apply.
Perfectly said. It's a strict filtering mechanism to prevent the courts from being paralyzed by just abstract grievances or policing bad behavior between private citizens.
Okay, so let's assume we pass through those filters. We have a defendant with clear standing and a police officer who undeniably violated the Fourth Amendment, say, by searching a home without a warrant. The rules were broken. This forces us to confront the so what. What is the actual tangible consequence when the government violates the Constitution?
This is where we have to separate the abstract constitutional right from the legal remedy used to enforce it. In American criminal law, the dominant remedy is the exclusionary rule.
Right, the exclusionary rule.
It dictates that evidence unlawfully seized by the government cannot be introduced at a subsequent criminal trial to prove the defendant's guilt.
I always think of the exclusionary rule like a penalty flag in football. The government commits a foul, the defense throws the flag, and the resulting play, like the discovery of the illegal drugs or the stolen weapon, is just nullified. It don't count.
That's a great way to picture it. The nullification is incredibly powerful, but there's a profound historical and legal reality that often surprises people. The exclusionary rule is nowhere in the text of the Constitution.
Wait, really? It's not in the text?
Not at all. The Fourth Amendment simply states the right shall not be violated. It offers zero instructions on the penalty for violating it. The exclusionary rule is an entirely judicially created mechanism.
Okay, so if it isn't in the Constitution, why did the Supreme Court invent it?
Pure deterrence. The justices recognize that if there is no consequence for an illegal search, the Fourth Amendment is basically just a polite suggestion. The logic is behavioral. If police know that evidence obtained illegally is totally useless in court, they lose the incentive to break down doors without warrants.
So the rule isn't designed to repair the privacy of the victim because that privacy is already gone. It is specifically designed to deter future police misconduct.
Exactly. And that explains why that penalty flag is highly conditional. If the goal is just to deter bad police work, the courts don't feel the need to apply the penalty in every single conceivable legal proceeding.
Right. My football analogy works perfectly here. It's a penalty flag that only applies during the Super Bowl, the main criminal trial, but it gets completely ignored during practice or entirely different sports.
Yes. Because it is a judicially created tool rather than a constitutional mandate, the courts have carved out a massive list of exceptions where the exclusionary rule simply does not apply. where the penalty flag just stays in the judge's pocket.
Let's run through those because the source text lists several of these heavily tested areas where the exclusionary rule does not apply. Let's start with grand jury
Okay,
proceedings.
so if a prosecutor is presenting evidence to a grand jury just to secure an indictment, they can freely use illegally seized evidence. The exclusionary rule is fully suspended.
How does the Supreme Court justify that?
They look at the historical function of the grand jury. It's an investigative body, not a trial determining ultimate guilt or innocence. Its job is just to determine if there's enough smoke to warrant a fire. Applying the exclusionary rule at the grand jury phase would transform a streamlined investigative process into this massive labyrinth of pretrial litigation over police conduct.
Makes sense. The rule is also suspended for federal habeas corpus review, right? So if a state prisoner is challenging their conviction in federal court, they generally cannot raise a Fourth Amendment claim if they already had a full and fair opportunity to argue it in the state courts.
Correct. The reasoning there is finality and federalism. The federal courts really don't want to endlessly relitigate state court factual findings. The deterrence value of throwing out the evidence years later on federal review is considered minimal compared to the massive cost of overturning a conviction.
What other proceedings are exempt?
Well, the rule does not apply to preliminary hearings, bail hearings, sentencing hearings, or proceedings to revoke parole.
So a judge can look at a pile of illegally seized weapons when deciding if you are a flight risk for bail or when adding years to your prison sentence.
They absolutely can. The same goes for civil proceedings. If the IRS wants to use an illegally seized ledger to prove you owe taxes in a civil tax court, the Fourth Amendment exclusion won't stop them at all.
Man, but the most philosophically interesting exception you mentioned earlier, and I know this is a huge trap on exams, is impeachment.
Yes, impeachment is fascinating. Let's say the police conduct a wildly unconstitutional search of your home and find a diary where you explicitly detail committing a robbery. Because of the exclusionary rule, the prosecutor cannot introduce that diary in their main case. They have to prove you committed the robbery using other legal evidence.
Okay, so the shield holds.
Until you take the witness stand in your own defense. You sit in the witness box, swear an oath to tell the truth, and then testify, I have never written a diary and I absolutely did not commit that robbery. You have fundamentally changed the game.
You open the door.
You kicked it wide open. The prosecutor can now pull out that illegally seized diary and show it to the jury.
To prove you are lying.
Precisely. They use it to impeach your credibility, to prove you are committing perjury. The Supreme Court's philosophy here is striking. The Fourth Amendment is a shield against government overreach. It is not a sword that grants you a license to lie under oath.
Wow.
The imperative of the trial to find the truth overrides the deterrence value of the exclusionary rule in that specific moment.
Okay, looking at this entire massive list of exceptions, grand juries, civil trials, bail, impeachment, it becomes incredibly clear for the MBE. If a question asks about a grand jury or a civil trial, the illegally seized evidence comes in, period. It is a highly conditional procedural tool.
That's the perfect takeaway.
So mechanically, how does a defense attorney actually wield this tool? You file a motion to suppress and a judge, not a jury, decides the outcome in a pretrial hearing, right?
Yes, the jury is entirely blind to the process. If the judge suppresses the evidence, the jury never even hears it existed. But if the judge denies the motion, the evidence comes in, the defendant is convicted, and the case goes up on appeal.
Which introduces those crucial standards of review. Let's translate de novo and clear error into simple English. When an appellate court looks at the trial judge's decision on a suppression motion, they are reviewing a mixture of law and facts.
Right. When it comes to questions of law, for instance, did the trial judge apply the correct legal definition of probable cause, or did they misinterpret a Supreme Court precedent? The appellate court uses the de novo standard.
Meaning, from the new, they look at it completely fresh.
Exactly. They grant zero deference to the trial judge's legal conclusions. The appellate judges are legal experts. They can read the law just as well as the trial judge, so they evaluate the legal standard from scratch. But the factual findings are an entirely different story.
Facts like, was the street lamp actually illuminated? Did the defendant slur their words? Did the officer have a clear line of sight?
Right, because the appellate court is just reading a cold paper transcript. They weren't in the courtroom to see if the police officer was sweating or avoiding eye contact or projecting absolute confidence on the witness stand. The trial judge was.
So the trial judge is in the best position to evaluate credibility.
Exactly. And because of that, the appellate court reviews factual findings under the clear error standard. They will defer heavily to the trial judge and will only overturn the factual findings if Based on the entire record, no reasonable judge could have possibly believed those facts.
Okay, the Ornelas v. United States framework. The law gets a fresh look, but the facts are basically locked in concrete unless the trial judge was glaringly, objectively wrong.
That's the dynamic.
So we've established the architecture of the right and the remedy. Now let's take it out onto the street. We need to define the exact moment this invisible shield gets engaged in the real world. What actually constitutes being seized by the government? Because obviously, a police officer just walking up and saying hello on the sidewalk isn't a constitutional event.
Right, not every interaction with law enforcement is a seizure. The Fourth Amendment doesn't activate until your liberty is actually restrained. The Supreme Court laid down an objective test for this in the landmark case Terry v. Ohio.
The famous Terry stop.
Exactly. A person is legally seized by the police in one of two ways. First, if the officer physically touches the subject with the intent to restrain them. Second, if the officer makes a show of authority without physical contact and the subject actually submits to that authority.
Let's pull on the thread of physical touch first, because the real world is chaotic. A police officer grabbing my wrist is a seizure. But what if the police use physical force and the suspect doesn't give up? What if an officer tackles me, I slip out of their grasp, and I keep sprinting down the alley? Was I seized for that one fraction of a second?
This exact friction was resolved pretty recently by the Supreme Court in a 2021 case called Torres v. Madrid, and the facts are honestly harrowing.
What happened?
Police officers approached a woman, Torres, who was sitting in her car in a parking lot. The officers were wearing dark tactical vests, and Torres, thinking they were carjackers, panicked and hit the gas to escape. The officers fired their weapons at the fleeing car, and 2 bullets struck Torres in the back.
Oh my God, but she didn't stop, right?
No, she kept driving. She managed to escape the parking lot, drove to a hospital, and was only apprehended later. The deeply philosophical legal question was she seized the moment those bullets hit her body, even though she didn't submit and wasn't captured?
That's a tough one because our everyday understanding of a seizure implies capture and control. If the bird flies away, it wasn't seized.
That was exactly the argument made by the dissent, led by Justice Gorsuch. He argued that a seizure requires actual possession. A mere touch that fails to stop the subject is an attempted seizure, not a completed one.
But what did the majority say?
Chief Justice Roberts, writing for the majority, looked back to English common law. The court ruled that the application of physical force to the body of a person with the intent to restrain them is a seizure, even if the person does not submit and is not subdued.
Wow, so the moment the bullets pierced her skin, the Fourth Amendment was triggered, and the use of force had to be evaluated for reasonableness.
Exactly. The application of physical force equals a seizure, period.
But you emphasize the phrase intent to restrain. And the source text highlights the immense weight of intentionality by contrasting 2 vehicular chase cases, Scott v. Harris and County of Sacramento v. Lewis.
These cases perfectly illustrate why the mindset of the government actor dictates the presence of the constitutional shield. In Scott v. Harris, you have a high-speed police pursuit. The fleeing suspect is driving recklessly, endangering the public. The pursuing officer makes a calculated decision to end the chase by intentionally ramming his police cruiser into the back of the suspect's car, running it off the road and causing a severe crash.
Okay, so the officer used their vehicle as a weapon with the explicit goal of stopping the suspect.
Yes, and because it was an intentional application of force designed to restrain movement, the Supreme Court held that it was unequivocally a seizure under the Fourth Amendment.
Okay, contrast that with the other case.
County of Sacramento v. Lewis is another high-speed chase, but this time involving a motorcycle. The fleeing motorcycle suddenly tips over on its own accord. The pursuing police cruiser, which was following too closely at high speeds, cannot brake in time and accidentally strikes and kills the passenger who had fallen off the motorcycle.
That is a catastrophic outcome resulting directly from a police action.
A total tragedy. But the legal classification is entirely different. The Supreme Court ruled that the passenger was not seized.
Because it wasn't intentional.
Precisely. The officer did not intentionally apply force to stop the passenger. The collision was a tragic accident. A Fourth Amendment seizure requires a willful, intentional act by the government designed to terminate freedom of movement. Accidental application of force, no matter how lethal, is not a constitutional seizure.
Man, it's a razor-thin doctrinal line. A bullet fired on purpose is a seizure. A bumper hitting you by accident is not. But it aligns perfectly with the idea that the Constitution protects against deliberate government overreach. You cannot overreach by accident.
That's a great way to put it.
Okay, that covers physical force. The other half of the Terry rule is a show of authority. Things like flashing police lights, a commanding voice yelling, "Stop right there,"
Right.
drawing a weapon.
Exactly.
If an officer yells, "Stop," and I freeze, I have submitted to their authority, I am seized. But many interactions aren't that explicit. What if a uniformed officer just walks up to me while I'm sitting on a park bench and starts asking me where I was last night? Am I seized?
For those ambiguous conversational situations, the court relies on the free-to-leave test. They evaluate the totality of the circumstances, the number of officers, the tone of voice, whether weapons were displayed, whether they are blocking your path, and ask an objective question.
Which is?
Would a reasonable, innocent person in that specific situation feel free to decline the officer's requests or otherwise terminate the encounter and walk away? If the answer is no, a seizure has occurred.
Let's talk about how this objective standard leads to a highly tested MBE vulnerability regarding traffic stops, specifically detailed in Brenlin v. California.
Oh, this is a huge one.
Okay, so I'm driving down the highway and my friend is in the passenger seat. A police cruiser flips on its sirens and pulls us over. By pulling the car to the shoulder, I, the driver, have obviously submitted to the officer's show of authority. I am seized, but what about my innocent friend in the passenger seat? They aren't in control of the vehicle. They didn't commit a traffic violation. Are they seized?
The Supreme Court in Brenlin answered this with a definitive yes. During a traffic stop, not only the driver, but all passengers in the vehicle are deemed to be seized.
Wait, why? Why is the innocent passenger legally detained?
Apply the free-to-leave test. If you are sitting in the passenger seat of a car that has just been pulled over by a police cruiser with flashing lights, would a reasonable person feel free to simply open the car door, step out onto the highway, and walk away?
Absolutely not. You'd get yelled at or worse.
Exactly. The show of authority is directed at the vehicle and everyone inside it. And this classification is critical because of standing. Because the passenger is seized, the passenger's personal invisible shield is engaged.
Ah. So the passenger now has the legal standing to challenge the constitutionality of the initial traffic stop.
You got it. If the officer pulled the car over illegally, say purely based on an arbitrary hunch with no reasonable suspicion, the passenger can file a motion to suppress any evidence found on the car that implicates them, arguing, "You illegally seized my person by stopping this vehicle."
So let's recap this for our listeners. The free-to-leave test is your guide for ambiguous situations. Would a reasonable, innocent person feel free to decline the officer's request? And remember, the MBE trap. Passengers in pulled-over cars are seized.
Yes, and to conclude the mechanics of seizures out on the street, we just need to quickly distinguish between the two levels of intentional detention: a temporary stop and a full arrest.
Both are seizures.
Both are seizures, but they require different burdens of proof. A temporary investigatory detention, a Terry stop, is a brief restraint on your liberty to ask questions and dispel suspicion. Because it is brief, it only requires a lower standard called reasonable suspicion.
Kind of a full arrest.
A full-blown arrest, where you are taken into custody and booked, is a massive deprivation of liberty. It requires the higher standard of probable cause.
Okay, so understanding the exact moment a seizure occurs, whether by physical touch, a bullet, or submission to flashing lights, is the prerequisite for evaluating whether the officer had the right level of suspicion to justify it. But everything we've discussed so far assumes the encounter is happening out in the open, in a car or on the street. The Fourth Amendment's architecture changes radically when we approach the front door of a house.
It does. The home is the apex of Fourth Amendment protection. It is the ultimate sanctuary. The Castle Doctrine heavily influences constitutional law here.
Okay, so we know an arrest warrant requires a detached and neutral magistrate to find probable cause that a specific person committed a specific crime. But when the target of that warrant is inside a building, how do arrest warrants function when walls and doors are involved? What does it actually let police do to physical property?
The foundational rule comes from Peyton v. New York. The Supreme Court held that an arrest warrant implicitly authorizes the police to enter the arrestee's own home to execute the warrant, provided they have a reasonable belief that the arrestee is currently inside.
So they don't need a search warrant, too?
Nope. They do not need to go get a separate search warrant for the house. The arrest warrant itself is sufficient to breach the fortress of the person specifically named on the document.
Okay, if it's my warrant and my house, the door comes down. But let's introduce the friction of third-party property. Let's say I'm a fugitive. The police have an active arrest warrant for me, But instead of hiding at my own house, I'm hiding out at your house.
Okay, I see where this is going.
The police track me down. Can they take my arrest warrant, march up to your front door, and kick your door down to come arrest me?
This scenario is one of the most elegant intersections of constitutional rights, and the answer is a resounding no. The police cannot use an arrest warrant for you to breach the sanctity of my home.
Wait, even if they have absolute ironclad proof that I am currently sitting on your couch?
Even then, the governing case is Stiegel v. United States. The Supreme Court ruled that absent consent from the homeowner or a genuine emergency, what we call exigent circumstances, the police need a specific search warrant to enter a third party's home to look for a suspect.
So my arrest warrant does not override your property rights?
Exactly. My home is my castle. Your status as a wanted fugitive does not magically dissolve my invisible shield. The police have to go to a magistrate and obtain a search warrant that explicitly states, "We have probable cause to believe the suspect, John, is hiding in this specific third-party location."
Which creates a fascinating double-edged sword when the police violate this rule. This is a huge MBE trap. Let's walk through the exact consequences of a Stiegel violation, which is highlighted in United States v. Agnew.
Okay, set the scene.
I'm hiding in your house. The police only have my arrest warrant. They are too impatient to get a search warrant for your property. They illegally kick down your door. They burst into your living room. They tackle me. And while they are putting the cuffs on me, they notice a large quantity of illegal narcotics sitting out on your coffee table.
Sounds like a mess.
A huge mess. Two people just had their lives upended. Me, the arrestee, and you, the homeowner. Let's process the legal rights one by one. Let's start with you, the homeowner.
Okay, from my perspective as the homeowner, the police breached my home without a search warrant, without my consent, and without an emergency. They blatantly violated my Fourth Amendment rights.
So the exclusionary rule kicks in.
Exactly. Applying the exclusionary rule, any evidence they discovered as a result of that illegal entry, the narcotics on my coffee table, must be suppressed. I cannot be successfully prosecuted using those drugs.
The homeowner's shield holds firm. But what about me, the arrestee? The police literally broke the law, committing an unconstitutional entry to get to me. I should be able to get my arrest invalidated, or at least suppress any evidence they found near me, right?
This is the trap that catches so many practitioners and students. No, you cannot.
But the entry was illegal. They broke the rules.
It was illegal regarding my rights, not yours. This requires synthesizing the rule of homes with the rule of standing that we talked about earlier. Do you, a fugitive hiding out, have a reasonable expectation of privacy in my house?
Oh, no, I don't.
The courts say no. You do not acquire a greater right to privacy by trespassing or hiding in someone else's home than you would have in your own. The police possessed a valid arrest warrant for you. They had the constitutional authority to seize your person.
Wow.
The fact that they violated my property rights to access you does not grant you a magical immunity. You cannot vicariously assert my Fourth Amendment rights to invalidate your own arrest.
That is genuinely staggering to conceptualize. So let me do an MBE focus recap here. Arrest warrant for your own home. Okay, they can come in. Arrest warrant for your friend's home. They need a search warrant, otherwise the friend's rights are violated. But the double-edged sword is that the homeowner gets the evidence suppressed, while the arrestee still goes to jail.
It is the ultimate manifestation of standing. The court's logic is laser-focused on the specific individual claiming the injury.
All right, we've established that warrants are strictly required to penetrate the fortress of the home, whether it's your own or a third party's. But human beings don't spend their entire lives indoors. This brings us to Section 6, warrantless arrests.
Right, the public exceptions.
When can the state, or even an everyday citizen, deprive someone of their liberty without a judge's prior approval?
Well, the constitutional calculus changes drastically the moment you step outside your front door. While the home is a fortress, the Supreme Court has ruled that in a public place, police generally do not need a warrant to make a valid arrest.
Really?
Yeah.
Just out in the open?
Yes. This was cemented in United States v. Watson. If you are standing on a public sidewalk and an officer has probable cause to believe you committed a felony, they can arrest you right then and there, even if they had plenty of time to go get a warrant beforehand.
Okay, but what if I see them coming? Let's say I'm standing on my front porch, which is publicly visible. I see the squad cars rolling up to arrest me without a warrant. I immediately turn around, sprint inside my house, and lock the door behind me.
Nice try.
Can I force the police to halt, go back to the station, and get a warrant just by retreating into my castle?
No. You cannot defeat an arrest that legitimately began in a public place by retreating into a private sanctuary. The governing case here is United States v. Santana.
So they can just follow me in.
If the police initiate a valid public arrest and you flee into your home, the chase is on. It creates an exigent circumstance known as hot pursuit. They can follow you right through your front door without a warrant.
You can't just touch base to be safe.
Exactly. No ollie ollie oxen free in constitutional law. Now, the rules for exactly when an arrest can happen without a warrant depend heavily on the nature of the crime and the actor. Let's look at police officers first. An officer can make a warrantless arrest if a crime, either a felony or a misdemeanor, is committed right in their presence.
Define presence. Do they have to witness the crime with their own eyes?
Not exclusively eyes. Presence means perceived through any of their senses, seeing a fight, hearing a gunshot, or smelling contraband. In District of Columbia v. Wesby, the Supreme Court clarified the standard. The test is whether the officer could conclude, considering the totality of the surrounding circumstances, that there was a substantial chance of criminal activity.
So they don't need absolute mathematical certainty.
No, they just need a substantial chance based on their immediate sensory observations.
Okay, if the crime happens in front of them, they can arrest for anything. But what if the crime happened yesterday? It's no longer in their presence.
If the crime was committed outside their presence, the power of a police officer to make a warrantless arrest is restricted to felonies. They must have probable cause to believe a felony occurred and probable cause to believe this specific individual committed it. They cannot make a warrantless arrest for a past misdemeanor.
Okay, that covers the police. But the source text outlines a concept that feels incredibly dangerous in modern society. Citizens' arrests.
Oh, this is a fascinating area.
Let's say I'm walking down the street and I witness what I think is a severe crime. Can I, a private individual, lawfully arrest someone?
You can, but the legal parameters for private citizens are incredibly strict, far stricter than for sworn officers. It operates almost like a strict liability trap, and the MBE loves to test this.
What are the rules?
A private citizen can only make a warrantless arrest if two distinct conditions are met. First, a felony must have actually been committed. There is absolutely no room for error or reasonable suspicion regarding the existence of the crime.
So if a cop makes a mistake, they are protected. But if I make a mistake, I'm in trouble.
Exactly. If a police officer arrests someone for a felony based on probable cause, and it later turns out no crime actually occurred, the officer is protected by qualified immunity. But if a private citizen makes an arrest and they were mistaken about the crime occurring, that citizen is completely exposed to civil lawsuits for false imprisonment, battery, and kidnapping.
Wow. Okay, so the first condition is absolute certainty of a felony. What is the second?
The second condition is that the private individual must reasonably believe that the specific person they are arresting is the one who committed that actual felony. So, the crime itself must be an objective fact, while the identity of the perpetrator allows for reasonable belief.
It makes citizens' arrests an incredibly high-risk proposition.
Yes, very high risk.
Let's pivot back to police power and misdemeanors. We established officers can arrest for misdemeanors committed in their presence. But how far down the spectrum of minor crimes does that power extend? The text cites a truly polarizing case, Atwater v. Lago Vista.
Atwater is a fascinating study in the limits of Fourth Amendment protection. So, a mother, Gail Atwater, was driving her children home from soccer practice in Texas. Neither she nor her children were wearing seatbelts.
Okay.
Under Texas law, a seatbelt violation was a misdemeanor, punishable only by a small maximum fine of $50. There was no jail time attached to the offense itself.
So the officer pulls her over, writes her a $50 ticket, and she goes on her way, right?
That is what normally happens. But in this case, the police officer decided to effectuate a full custodial arrest. He handcuffed her in front of her children, placed her in the squad car, drove her to the police station, had her mugshot taken, and put her in a jail cell for an hour before she could post bond.
For a seatbelt violation, that feels like a massive, disproportionate abuse of state power.
She argued exactly that. She sued, claiming that a full custodial arrest for a minor fine-only traffic offense was fundamentally an unreasonable seizure under the Fourth Amendment. She argued the Constitution must surely demand some proportionality between the severity of the crime and the severity of the seizure.
What did the Supreme Court say?
In a sharply divided 5-4 decision, they disagreed with her.
The Supreme Court said that was constitutional.
Yes. The majority ruled that if an officer has probable cause to believe an individual committed even a very minor criminal offense in their presence, they may arrest the offender without violating the Fourth Amendment. The Constitution does not forbid warrantless arrests for fine-only misdemeanors.
That is wild.
Justice Sandra Day O'Connor wrote a blistering dissent, warning that this ruling granted police unbounded discretion to use minor traffic codes as a pretext to arrest anyone at any time, subjecting them to the indignity of a jail cell. But the majority prioritized a bright-line rule for law enforcement over a complex proportionality test.
So the invisible shield offers zero protection against being hauled away in handcuffs for a traffic ticket, provided the officer witnessed it.
Basically, yes.
Which forces us to confront the ultimate pragmatic question, the million-dollar reality check for any defense strategy. We've explored the rules for warrants, standing, homes, and public arrests. Let's say the police completely and spectacularly botch it.
Okay, worst case scenario.
They have no probable cause, no warrant. They kick down my door for a minor misdemeanor that happened weeks ago. It is an undeniably illegal, unconstitutional arrest. Does that mean I beat the charges? Do I walk free because the state broke the rules bringing me in?
I have to crutch that hope. An unlawful arrest, in and of itself, has absolutely no bearing on the validity of a subsequent criminal prosecution. It is not a defense to the crime charged.
That creates a massive paradox. If the state can literally kidnap me illegally and still put me on trial, doesn't that inherently incentivize the police to break the rules, as long as they don't need physical evidence from the arrest?
It's called the Kerr-Frisbee doctrine. The Supreme Court has consistently held that the government does not lose the right to try a defendant just because they brought him into the court's jurisdiction illegally. The court's authority to try you is not voided by the police officer's misconduct outside the courtroom. An illegal arrest does not grant you immunity from prosecution.
Let me do a quick MBE recap here. An illegal arrest gets evidence thrown out, but it does not get your case dismissed. But what is the actual penalty for the botched arrest then?
We return to the exclusionary rule. The illegal arrest does not dismiss the case, but it suppresses the evidence derived directly from that arrest. If the police illegally arrest you, and during that unlawful seizure they search your pockets and find illegal narcotics, those narcotics are suppressed. They cannot be used at trial.
Okay, so I still face prosecution, but the state has to prove its case without the fruits of their illegal action.
Correct.
That makes logical sense for physical evidence in your pockets. But what if the evidence is psychological? What if I am illegally arrested, dragged into an interrogation room, and I voluntarily confess to the crime? Does a confession get thrown out just like physical drugs?
This is a highly nuanced area governed by the attenuation doctrine, specifically detailed in Wong Sun v. United States. A voluntary confession made after an unlawful arrest is not automatically suppressed just because the initial arrest was unconstitutional.
Oh, really? How does the court figure out if it stays in?
The courts conduct a complex analysis to see if the confession is too closely tied to the illegal act, if it is the fruit of the poisonous tree. They look at the time gap and intervening circumstances.
Like how long it's been.
Exactly. The police illegally kick down your door, throw you to the floor, and 20 seconds later you scream, "I did it." That confession is almost certainly getting suppressed. The causal chain is unbroken. The confession is a direct product of the shock of the illegal entry.
But what if time passes?
Right. Let's say you are illegally arrested. You are released on your own recognizance. You go home, you sleep in your own bed, you consult with an attorney, and 3 days later, you willingly drive back to the police station and sign a full confession.
The chain of causation has been broken.
Precisely. The taint of the illegal arrest has faded. Your decision to confess was an independent act of free will, sufficiently attenuated from the initial police misconduct. That confession will be admitted into evidence despite the original illegal arrest.
Wow. Synthesizing this entire landscape, from standing to government actors to the mechanics of a seizure to the final limits of the exclusionary rule, the overarching theme of the Fourth Amendment is pragmatic limitation. The courts are constantly trying to balance the immense power of the state against the privacy of the individual, but they do it through strict procedural gates.
They really do. You don't get the shield just because you were near a violation. You have to prove it was your door, your property, your liberty that was intentionally breached by the state.
It removes the emotion from the scenario and applies a rigorous, almost mathematical logic to constitutional rights. Do you have standing? Was it the government? Was it a seizure? Does an exception apply?
Yes, you have to locate the exact actor, the exact moment of the seizure, and the exact physical space to determine if the remedy applies.
Before we close up this deep dive, I want to pivot from the historical architecture we've discussed to a genuinely provocative challenge for the future. We've spent this entire time talking about the Fourth Amendment as a physical barrier. Cops kicking down wooden doors, bullets striking physical bodies, searching physical
The
pockets.
physical trespass doctrine.
Right. And we discussed how the Fourth Amendment strictly regulates the government when it seizes those physical things. But we are living in a post-physical world. Most of our papers and effects aren't in a desk drawer anymore. They are terabytes of data sitting on servers owned by Google, Apple, and private data brokers. They track our location, our heart rates, our purchases.
It's a totally different landscape.
Now, under the third-party doctrine, you generally lose your expectation of privacy when you voluntarily give information to a third party. But here is the terrifying evolution.
Okay.
What happens when the government stops doing the searching and just starts opening its wallet?
The privatization of surveillance.
Exactly. If a police department wants to track your movements without a warrant, they don't need to illegally plant a GPS tracker on your car anymore. They can just go to a commercial data broker and legally purchase the geofence data of your smartphone.
Which fundamentally bypasses the entire constitutional framework we just analyzed.
If the Fourth Amendment only restrains the government from unreasonably searching and seizing, does the invisible shield completely vanish in a capitalist market where the government acts as a customer rather than an investigator?
The state action doctrine, warrants, the exclusionary rule. None of it applies to a commercial transaction.
So the question to ponder as we move forward and continue studying this, if the government can simply buy its way around the Fourth Amendment, do we still have a constitutional right to privacy, or do we just have a pricing model for our liberty?
Something to heavily consider as technology outpaces centuries-old case law. The invisible shield is always shifting. Keep your eyes on it.